Well, right now there is a lot of confusion, uncertainty, and speculation arising out of the most recent hearing in the Karen Read case, the hearing that was suspended in the middle of the hearing when Judge Cannone said we're going to suspend the hearing and continue the hearing next week. So probably the smartest course of action is to just wait for next week when everything will hopefully become cleared up. But up until that point, there is still plenty to discuss in the Karen Read case. Number one is that there's going to be a motion to dismiss filed by tomorrow. Tomorrow is the deadline to file this motion to dismiss, and it's going to be based on Brady violations and Rule 14 violations. These are violations where they did not get certain videos from the Sally Port up until after the first trial, even after the first trial, where they had this video of Brian Higgins on the phone at 1:30 in the morning at the Canton Police Department, contrary to his testimony. And there's the lack of preservation of the videos, and there's going to be some other claims why this entire case should be dismissed. So that motion is going to be filed by tomorrow. There's also some motions that were not argued in the hearing because the hearing was suspended. And one of those motions was a motion for sanctions. Motion for sanctions filed by the Commonwealth, and there's also a motion for sanctions filed by the defense. And that's exactly what we're going to be talking about today. I want to talk about this motion for sanctions. David Yannetti kind of started out with this motion, and then the judge says, okay, only argue part of the motion. We're going to wait for the motion for sanctions for later. So we're going to open up that entire motion and talk about it because it's very interesting. And also, again, we're going to find something that's unique to Massachusetts that many other jurisdictions do not have the same rule. So let's pull up that motion. And then we're going to be going through some of the motion from the defense that was filed. And then the Commonwealth, because of something that was mentioned in this motion, that's why Hank Brennan filed a motion for sanctions on his own, because of something that was said in this motion. So we have to first see the defense's motion before we even get to the Commonwealth's motion for sanctions. So let's pull it up and we'll go through certain parts of this motion. All right, here we go. Ms. Read faced a trial by jury for the above crimes beginning on April 16th, 2024. Seems like a long time ago. Prior to the commencement of the trial, the Commonwealth submitted a motion for reciprocal discovery and notice of any experts filed on March 21st, 2024 with this court. So this is a motion that was filed by the Commonwealth. They're talking about, this is the defense's motion, but the defense's motion in this motion is talking about a previous motion that was filed by the Commonwealth for reciprocal discovery on March 21st, 2024. Paragraph 4 of the Commonwealth's motion requested production from the defendant of any written or recorded statement as well as any oral statement reduced to writing of any individual whom the Commonwealth intends to call as a witness at trial, including but not limited to such statements contained in defense investigative reports or other non-legal reports. So this is the Commonwealth's motion that they're talking about, where the Commonwealth is asking, this is, at that point, it was Adam Lally, asking for any written or recorded statements that have to do with witnesses that the Commonwealth is going to be calling. Okay, now, generally speaking, let's just talk about discovery in general. Discovery in general is you turn over the information on your witnesses. I turn over the information on my witnesses. But here you have the Commonwealth asking for the defense to turn over information that they have on the Commonwealth's witnesses who they intend to call. So that's interesting by itself. Let's move on and then we'll discuss all this whole idea. The Commonwealth's motion was allowed by this court. So the judge can only say, yep, the defense now has to turn over any sort of information, all these statements and writings, reports by their investigators. They have to turn over all that information that they have about the Commonwealth's witnesses. So let's say, for example, they have all this information on Jennifer McCabe that they're going to be using for cross-examination. Well, they have to turn that over to the Commonwealth. So the Commonwealth gets to see what information, what documents, and what statements I'm going to be using, or what the defense is going to be using in their cross-examination of, for example, Jennifer McCabe. This is what the judge allowed. The Commonwealth's motion was allowed by this court, requiring the defendant to turn over evidence intended to be used as impeachment evidence against witnesses called by the Commonwealth prior to those witnesses being called to testify at trial. Now, what do you think is going to happen? Let's just take a step back for a minute. If I give you all of the information that I'm going to be using to cross-examine your witnesses, what do you think you're going to do with your witnesses before they take the stand? Well, of course, you're going to show them what the defense is going to be using to cross-examine them and make them look silly. And then you're going to prepare them for that cross-examination. Well, how effective is that cross-examination going to be now? Not as effective as it would have been if they wouldn't have known what's coming down during cross-examination. Well, let's continue. On several occasions during various Commonwealth's witnesses' testimony at trial, the witnesses subsequently tailored their testimony and included details which had not previously been discussed to account for the impeachment evidence turned over by the defense. So they're saying this is exactly what happened. We turned over this information. They never even thought about talking about this information, but now they realize, oh boy, they're going to really get chewed up by the defense. So they have to figure out how to change it. So that's what we can see. So now they're going to give examples where you see that this was done. So for example, at trial on May 21st, 2024, Jennifer McCabe testified for the prosecution. During cross-examination, Ms. McCabe testified that on January 30th, 2022, the day after John O'Keefe had been found in front of 34 Fairview Road, she went to the house of Canton Police Lieutenant Michael Lank. Well, that's a very interesting visit there, right? Now, prior to this testimony, Ms. McCabe had never disclosed publicly or in any report or witness interview, even when asked directly about her meetings and conversations in the days and weeks following January 29, 2022, that she visited the house of one of the responding officers to 34 Fairview Road. So she never mentioned this before. She never mentioned that she went casually over to Sergeant Lank's home. Oh, and Sergeant Lank was one of the people that investigated this murder. She never mentioned that before. Ms. McCabe, who is friendly with Mike Lank and knew of him growing up, testified that she could have been at Lieutenant Lank's house for an hour. After initially denying having entered Lieutenant Lank's house during the hour that she was present, she then remarked how she might have ran in to go to the bathroom. When asked why she had never testified to this incident before, Ms. McCabe responded, "I guess I never thought much of it." So all of a sudden, right, why would you think anything much of going to stop by the day after this whole murder and going to one of the investigators' officers' house? Why would you think that's important? Oh, I never thought that was important. That's what she responded to in when she was asked about this in cross-examination. The only time Ms. McCabe claimed to have discussed this meeting with anyone related to the case was at the DA's office with Mr. Lally, Mrs. McLaughlin, Steve Nelson, and Trooper Brian Tully. Ms. McCabe confirmed that at that meeting with the prosecution, she was specifically asked about her meeting at Lieutenant Lank's home, something which she had never revealed and about which she had never previously been questioned. So all of a sudden, it seems like they're getting ready for trial, and the prosecution's getting together with Jennifer McCabe and saying, hey, look, you got to figure out what we're going to do with this. What are we going to do with this information that you never told anybody about? And if you've never told anybody about it and you don't even know that they're about to cross-examine you on it, obviously the surprise of that to the jury would be more noticeable. So they got this information, and it seems like they collaborated with Jennifer McCabe, prosecution, said, okay, what are we going to do with this? All right, continuing. At trial, she saved this information for cross-examination. After questioning Ms. McCabe about a different topic, Attorney Jackson asked Ms. McCabe, did anything significant happen on January 30th in connection with this case? Any meetings? Any get-togethers? Anything that you can think of? Ms. McCabe responded, I went to the O'Keefe's house. Attorney Jackson followed up, other than that, anything else? In response to this open-ended question, without any indication from Attorney Jackson regarding the answer he was seeking, Ms. McCabe volunteered this thorough answer. Definitely looks like it was prepared, right? Oh, on the way home, Carrie Roberts' daughter is good friends with Michael Lank, so we dropped her off at Michael Lank's house, and Mike's wife came out of the house. Him and Carrie are friends, and she, jumped in the car and was consoling Carrie and asks how the O'Keefes were doing, and, we talked to her. This extremely detailed and comprehensive explanation as an answer to Attorney Jackson's open-ended question accompanied by Ms. McCabe's testimony that she had been asked about this meeting by Mr. Lally at the DA's office leads to the inescapable inference that Ms. McCabe was prepared for this impeachment question in advance of trial. Right? That they all figured that out, and that's why they got together to figure out what they're going to do with this information. That was only possible because, in compliance with this court's impeachment evidence reciprocal discovery order, the defense had turned over location data obtained from Ms. McCabe's cell phone to the prosecution on May 6, 2024. So this is part of the disclosures that they were required to turn over pursuant to that motion. And this was information that they saw that she has location data from her phone that she was at Officer Lang's house. So they had to turn that over. Once they turned that over, now the prosecution knew what they were going to impeach Jennifer McCabe with, and now they got together and figured out how to deal with it, how to diffuse it. This location data showed that Ms. McCabe was indeed present at Lieutenant Lang's personal home for approximately 45 minutes on January 30th, 2022. Although the Commonwealth did not elicit this information during its direct examination, Ms. McCabe had clearly been prepared for the question on cross-examination as a result of the defense production of impeachment evidence. Okay, so that's one example where you see clearly that because of this motion that was granted by the judge, and the defense had to turn over all of their impeachment information that they're going to be using to impeach Jennifer McCabe and all the witnesses, by the way, they were able then to prepare her, and now she was very much prepared how to deal with that question. And that's what she gave that answer of their daughter being friends with everybody, and then it seemed so innocent. Another example occurred at trial on May 28th, 2024, when PF is a pseudonym, talking about a minor witness. This is most likely John O'Keefe's nephew, testified for the prosecution. PF, who was 11 years old at the time of Mr. O'Keefe's death and 13 years old at the time of his testimony, described his experiences with the defendant. During a SANE interview on February 22nd, 2022, PF had testified about an incident with the defendant wherein she got really mad at him. Right? PF described how one time I had like steak tips and I was just eating them slowly because they were hard to chew, and she got really mad at me for it because she thought I didn't like them and I was spoiled and stuff. So that was what he was going to testify about. Now, during trial testimony on May 28th, 2024, PF was questioned by the prosecution about the same incident. Prior to that testimony, Attorney Yannetti expressed his concerns about this line of questioning at sidebar, stating that there was testimony in the grand jury about my client supposedly getting mad at PF for eating his steak too slowly. We provided a video of that incident to the prosecution, which belies that testimony. So they've got a video of that incident, and guess what? Karen Reed is not upset at all. They're having a good time. So what exactly, seems like pretty good impeachment stuff material for PF. Now, PF's a kid. You don't want to chew him up on the stand. But if that's the way he's going to testify, then there's going to be some pretty strong impeachment video showing that that's actually not the case. So was he coached to say that? That's the question. That's the insinuation. Attorney Yannetti was expressing his concern that PF's trial testimony would diverge from the grand jury testimony as a direct result of the defense production of pure impeachment material to the prosecution on May 6, 2024. This is, of course, exactly what happened mere minutes later. So this is exactly what happened. PF was asked by the prosecution about instances where he was yelled at by the defendant. And listen to how the story changes. He recounted one time we got takeout food. Nothing about steak bits. And I was taking a little while to eat it, and the defendant, though I didn't appreciate it, so she got mad at me. 2 weeks prior to his testimony at trial, the defense turned over a video depicting PF eating steak tips, interacting with Ms. Reed in a playful manner, wherein she never gets mad, directly contradicting his SANE interview from February 2022. PF undoubtedly met with the prosecution in preparation for his testimony. This resulted in PF changing his story to claim that it was takeout food and not steak tips that he had been eating, so that he can now claim that the defense impeachment video does not depict the incident he initially revealed. So now he wants to say, well, look, that was a different time. That steak tips, that was not what I was talking about. Yeah, she was very friendly at that time. I really meant about this takeout food incident, which, you don't have a video about. Oh yeah, but you should trust me that at that time she got very mad at me. Okay. So the point is that they're showing that when we have to turn over all of our impeachment information, they're able to now change testimonies to be able to diffuse all of our good points that we're going to be making on cross-examination to show that you guys are coaching your witnesses, or you're creating stories that aren't so accurate, and it takes away from the credibility of the witnesses. So therefore, the initial motion, and this is what Yannetti argued actually on that day for the hearing, this was argued, and Hank Brennan argued back, was that he wants the judge to reconsider. He's saying, Judge Cannoni, you should reconsider your ruling. Your initial ruling was that we have to turn over all this information, which is very helpful for us to impeach the witnesses. And you're taking away the entire surprise because we have to hand it over. And once we hand it over, they sit down and prepare with their witnesses to make sure that we don't have any solid cross-examination. So he's asking the judge to reconsider that ruling. Now, on top of that, he's going to be asking for sanctions. Why is that? And here we go. Sanctions may be imposed upon non-complying parties to remediate the violation in a way the court sees fit. So what violation was there? Well, here's the argument that there was a violation according to the defense. Similarly, when a sequestration order in place with respect to witnesses at trial is violated, the judge has discretion to remediate the violation, including to admit or exclude the testimony of witnesses who have violated sequestration orders. So if a sequestration order was in place and it was violated, then the judge could sanction the witnesses or sanction. So how is she going to sanction the witnesses? Well, in certain cases, you could exclude that testimony. Right? If that testimony is going to be damaging for you, and this other person violated that order, so then the judge can say, okay, you're not allowed to testify anymore. Well, that's not really what they want in this case, because they're going to be talking about Michael Proctor. They want Michael Proctor to testify. So what's going to be the argument here? Well, here's what they argue. Additionally, the defense believes that violations of the sequestration order occurred during the first trial. In addition to the inclusion of testimony not adduced at previous hearings, as we mentioned earlier, a message from one of the witnesses from the first trial demonstrates that at least one witness likely violated the sequestration order with the knowledge of the prosecution. What are they talking about this? On July 1st, 2024 at 5:48 and 21 seconds p.m., prosecution witness Trooper Michael Proctor sent a text message to Assistant District Attorney Adam Lally that stated, didn't watch A-hole Jackson's closing for good reason. Like all of us, the anticipation and anxiety of verdict has us all on edge. So that is a text from Michael Proctor to Adam Lally saying that he didn't watch the closing argument. Now, why should he be not allowed to watch the closing argument? Because you have a sequestration order. You're not allowed to watch the trial. That should be the reason why you're not watching, right? But let's continue. Let's see what the argument is. Subject to protective order due to personal. Now they say here, look at this. This is where the Commonwealth is going to argue for sanctions. See, it says here, see screenshot of Proctor's text message to Lally from July 1st, 2024, subject to protective order due to personal identifying information. And the entire Commonwealth's motion for sanctions is based on this paragraph in this motion, because the Commonwealth, Hank Brennan, is going to argue in his motion for sanctions that Yannetti violated this protective order. There was a protective order that was entered into about any sort of communications from the witnesses from the Commonwealth, and they were not allowed to turn over this stuff. They're not turned over to the public, and they're not allowed to make it part of a public filing. Like this is a public filing. So here it looks like this is becoming public information, and it's a violation of the protective order. Now, what Yannetti is saying in this motion is they're saying this is subject to protective order due to personal identifying information. The reason why we entered into that protective order is so that personal identifying information is not disseminated to the public. So people don't know your personal cell phone number, that people don't know the witnesses' addresses or where they're staying, or any other personal identifying information. People know Michael Proctor. There's no number here. There's no address here. There's no nothing. So Yannetti is saying, look, I understand that there's a certain protective order governing communications, but the whole point of it is just to protect personal identifying information. And here I'm just saying what was written in that text message. Nevertheless, Hank Brennan is arguing that there should be sanctions against the defense in this case, because by stating what Trooper Proctor said in his text message about the closing of Jackson, that's really violates the protective order. So that's in terms of the Commonwealth's motion for sanctions. But let's continue with the defense's motion for sanctions. So this is part of the request for sanctions, saying that, look, Michael Proctor's talking about the closing argument. Mr. Proctor's message suggests that his decision not to watch the proceedings on July 1st, 2024 was not out of an effort, out of effort to abide by the sequestration order, but was instead related nature of the defense closing argument itself. The message implies that Mr. Proctor had been following the trial online and simply skipped the defense closing argument because he does not like Attorney Jackson. That's why he was saying he didn't watch the closing argument. That's what they're trying to infer. That's what he's inferring from this message. He just didn't want to watch that a-hole Jackson close this case. Instead of saying, well, of course I didn't watch the trial because I have a sequestration order. That's why I'm not watching the trial. So that is the second reason why he's going to be arguing, Yanetti's arguing, that what should the sanction be? The sanction should really be that the judge should just reconsider her order requiring us to turn over all this impeachment information. It's not continuing. After all, the defense is not requesting to withhold impeachment evidence until the very moment that the evidence would be sprung upon the witness on the stand. So what is he asking? Rather, in an effort to avoid impropriety rather than create it, the defense merely requests to withhold impeachment evidence until after the witness has testified on direct examination, such that the witness cannot unfairly preempt the confrontation. Once the witness's testimony is recorded, the defense would produce the relevant impeachment evidence that they intend to use upon cross-examination to the prosecution so they can adequately prepare for redirect examination. So what Yannetti is saying, look, we understand you want us to turn over this impeachment information. You don't want trial by surprise. Nobody wants trial by ambush, trial by surprise. Well, the problem is that when we give over this information beforehand, then they all see it and they prepare the witnesses, and that's not really fair. They should give their testimony as they remember it from their personal knowledge without knowing what we're going to cross-examine them at. Then we'll take a little bit of a break. We'll give over all of our impeachment information to the Commonwealth, to Hank Brennan. He can have as much time as he wants to review it. And then we will begin our cross-examination on their witnesses. And then afterwards, he can rehabilitate them knowing what we use for cross-examination. Now, it's not a terribly effective way to do things, but that's what he's suggesting here happens. So, continuing. Now, listen to the case that he quotes here. This is a very important case called Durham. It's an important case that has to do with discovery, with this specific issue. And listen to what this quote says. The effectiveness of cross-examination often depends on being able to surprise a witness. That is the whole teeth. That's the teeth of cross-examination. That you can surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his or her trial testimony. So that's really the whole point of cross-examination, that you're impeaching the witness, especially if it's an accusing witness, and you're impeaching them with some documents that they don't know about. And they don't remember. They don't know that they gave a certain statement or that you have some goodies on them that you're going to make them look like they're lying. So that's the whole effectiveness of cross-examination. Now, this really goes back into the right to be able to confront your witnesses. This goes back to a constitutional right that you have of confrontation. So, this is a quote that he's quoting from Durham. Now, why has this all become very interesting? The reason why this becomes very interesting is that the rule in Massachusetts, like I said, normally the rule is that you have to turn over information on your witnesses and the other side has to turn over information on their witnesses. But you don't have to turn over information that you have on their witnesses. They have business making sure that they get information on their own witnesses. Why do I have to give them information on their witnesses? They should make sure to get all that information themselves. Just because I'm a better lawyer than them and I dug up all this information that they didn't realize about their witnesses, I have to turn that over to them? That's not fair. So the rule in Massachusetts works the following. in Massachusetts, there's mandatory disclosures, and then there's disclosures by motion. The mandatory disclosures is the information on your witnesses. So the prosecution has to turn over on their witnesses, the Commonwealth has to turn over on their witnesses, and then the defense has to turn over on their witnesses. That's mandatory. You don't have to file motions. If you don't do that, you can file a motion to dismiss. That's the basic requirements that's straight out in the rule. Now, if you want this extra information, then you have to make a motion. Then you have to make a motion with the court saying, we want what they dug up on my witnesses. And then the judge has the discretion what to rule. That's what happened in this case. The Commonwealth at that point with Adam Lally filed this motion that we want all their information that they gathered on our witnesses. And Judge Cannone granted that. Now, what about that idea? What about that whole concept? Is that something that is normal? Is that something that's accepted by many jurisdictions? Or is this something that's rare? And it's something that's just in Massachusetts and maybe a couple of other jurisdictions. Well, wouldn't you know it? That this is actually something that's rare. Because most other jurisdictions understand that it's not fair. Just because I'm a better lawyer and I dug up information about your witnesses, why should I have to turn that over to you? That's your job. You don't do your job, I do your job for you, and now I have to turn it over, and now you can completely destroy my whole cross-examination? So let's take a look at the case of Commonwealth versus Durham, and look what it says here. And this is the dissent. So as you notice from that quote, I'll bring it back up for a second. You see this quote? It's from Marshall, who's dissenting. So this is Chief Justice Marshall, seems like, that he was dissenting in this opinion. So this opinion found that this is fine. A judge can order that the other side has to turn over information that they have on your witnesses. That's completely fine for the judge to do that. Marshall didn't like that. So when Yannetti is quoting from Marshall and it's a dissenting opinion, that doesn't really have too much authority. Okay? Doesn't have too much authority. Now, he did quote it, and he quoted it in his argument. But that's not the holding of that case, because he's a dissenter. He lost on that issue, Marshall. Now, it's a good argument, but that's not the law in Massachusetts. The law in Massachusetts is that the other side, if the judge rules that you have to turn over information on the other witnesses, then that's what you got to do. But still, he's still arguing the concept. So if we go back to Commonwealth versus Durham, this is what it says. To date, this is what he's saying in the dissent, Marshall. To date, only 2 states have provided for such discovery by rule and have done so explicitly. So there's only 2 other states who have done so explicitly, and then there's 5 others who have authorized this type of discovery in the absence of explicit language directing it. We are ill-advised to interpret our rule in a manner that is out of the mainstream, where there is no reason for the court to do so. So this is what Chief Justice Marshall says, that this is not a good idea for Massachusetts to do. This is what he's saying in this opinion. We should not allow this to happen because there's only 7 in total states. The 7 states in total that actually allow this. So he was very against this. And he wasn't the only dissenter here. There's some other dissenting justices as well. But this is where it's interesting that for some reason in Massachusetts, they allow this to happen. So the question is there a chance that Yannetti's motion is going to be granted? Probably not. Okay, it's probably not going to be granted in the asking Judge Cannone to revisit her order and not order them to turn over the information, even though it doesn't seem fair. A lot of things in this case doesn't seem fair, right? We keep bumping into this problem that things in this case aren't so fair, but still, that's the law in Massachusetts. That's the law that's got to be followed. So he's most likely not going to win this motion, and he's not going to win it as a sanction either. Because generally speaking, when it comes to sanctions and people witnesses violating sequestration orders, it's that they can't testify. Something that's to do with their testimony. Now, they want Michael Proctor to testify. It's just Yannetti was dressing this up as, well, let's throw this in as also a sanction that we don't have to turn over our impeachment information that we have on your witnesses. And also, if you think about it, for the administration of justice, it's not really terribly effective. Every time you have a direct examination, you're going to stop court, let the defense turn over everything they have on this witness to Hank Brennan, take a break, or maybe they go into the cross-examination, and then Brennan's going to have to look over this information to figure out how to do a redirect. It's not practical anyway. So this motion is not going to be granted, but I think it also just sheds light on this whole issue in Massachusetts, whether this is actually right or not, which seems to me that it's not. But, a number of states do this. It really, really takes a lot of the your strength of your cross-examination out of it. Now, Brennan's motion for sanctions against Yannetti for filing and for talking about this text message that Proctor sent to Lally after during that closing argument that Jackson was giving, that has yet to be decided also. So that's something that the judge Cannone is also going to be able to decide. And one of the remedies that he was asking for in that motion, Brennan, was that maybe the defense should have to file everything under seal, meaning we can't see it until it gets approval by the judge, and say, okay, there's nothing in this that violates the order, and now we can put it out to the public. So, can there be monetary sanctions? Sure, there can be monetary sanctions as well, but that seems to be the sanctions that Brennan is suggesting, which would obviously not be so comfortable for all of us. We want to see what's going on there as soon as possible. Not that it has to go through this process where everything's under seal, and then only after it gets released to the public. So that is what's going on with this motion for sanctions. So very interesting stuff. I think we still have the motion to dismiss. It's going to be filed tomorrow on Friday, which is February 21st. Then we have this hearing next week. There is a lot of action in the Karen Read case. So we're still going to be following it as we usually do, keeping you up to date, bringing you the legal analysis. If you haven't yet, please subscribe, like, and we will see you next time.